Hello everyone. Today we will discuss another topic under environmental studies and environmental law. Today we will discuss about polluter pays principles and public trust doctrine. Polluter pays principle is one of the recognized principle under the concept of sustainable development. The list of topics to be covered here are introduction, history and concept, global recognition, public trust doctrine, the purpose of doctrine and the origin of doctrine. The polluter pays principle imposes liability on a person who pollutes the environment to compensate for the damage caused and return the environment to its original state regardless of the intent. The polluter pays principle was first introduced in year 1972 by the Organization for Economic Cooperation and Development (OECD), guiding principles concerning international economic aspects of environmental policies, where under the polluter was held responsible for the environmental damage and pollution. Subsequently, the Rio Declaration laid down the guidelines for sustainable development, meaning thereby a strategy to cater the needs of the present generation without compromising the needs of the future generation. In furtherance of the aim of sustainable development, Rio Declaration Principle Number 16 enshrined that the polluter pays principle, stating the polluter should bear the cost of the pollution. The polluter pays principle has helped to mitigate the damage being caused to environment to some extent. The provision remains an inadequate remedy as ambiguity persists regarding clear identification of the actual polluter. The polluter may be a part of the production chain, and it is difficult to impose the liability on such polluter when the court considers the parameters of extent and contribution of causing pollution. Global recognition. Polluter pays principle is a globally well recognized and a much celebrated environmental principle. The primary function of the principle is that it helps in allocating the cost and repairing the damage between different stakeholders for the harm caused by them to the environment. The principle is also revolutionary in the sense that it places the responsibility of paying the damages to the persons who ought to pay it and also who have the ability to pay it. There are certain case studies with respect to polluter pays principle. In case of MC Mehta versus Kamal Nath and others, the court held that pollution is a civil wrong and it is a tort committed against the community as a whole. Thus, any person guilty of causing pollution has to pay the damages and the compensation for restoration of the environment and ecology. Under the polluter pays principle, it is not the role of government to meet the cost involved in either prevention of such damage or in carrying out remedial action, because the effect of this would be to shift the financial burden of the pollution incident to the taxpayer. Another case study of oleum gas leak, MC Mehta versus Union of India. The court laid down that an enterprise engaged in a hazardous or inherently dangerous industry which poses a potential threat to the health and safety of persons working in the factory and to those residing in the surrounding areas, owes an absolute and non delegible duty to the community to ensure that no harm results to anyone on the account of hazardous and inherently dangerous nature of the activity which it has undertaken. The enterprise is absolutely liable to compensate for such harm and irrespective of all reasonable care taken on his account. The larger and more prosperous the enterprise, greater must be the amount of the compensation payable for the harm caused on account of an accident in the carrying on of the hazardous or inherently dangerous activity by the enterprise. In the case of Vellore Citizens Welfare Forum versus Union of India, the court interpreted the meaning of the polluter pays principles as the absolute liability for harm to the environment extends not only to compensate the victims of the pollution but also the cost of restoring the environmental degradation. Remediation of the damaged environment is a part of the process of sustainable development, and as such, the polluter is liable to pay the cost to the individual sufferers as well as the cost of reversing the damaged ecology. In the case of Indian Council versus Enviro Legal Action versus Union of India, the court held that once the activity carried on is hazardous and inherently dangerous, the person carrying on such activity is liable to make the loss caused to any other person by his activity, irrespective of the fact whether he took reasonable care while carrying on his activity. The rule is premised upon the very nature of the activity carried on. Public trust doctrine. The public trust doctrine primarily rests on the principle that certain resources like air, sea, waters, and the forest have such a great importance to the people as a whole that it would be wholly unjustified to make them a subject of private ownership. The said resources being a gift of nature, they should be made freely available to everyone, irrespective of the status in life. The doctrine enjoins upon the government to protect the resources for the enjoyment of the general public, rather than to permit their use for private ownership or commercial purpose. Public trust doctrine serves two purposes. It mandates affirmative state action for effective management of resources and empowers citizens to question ineffective management of natural resources. The public trust doctrine has its origin in Roman law. It has been extended in recent years, placing a duty on the state to hold environmental resources in trust for the benefit of the public. At its widest, it could be used by the courts as a tool to protect the environment from many kinds of degradation. In some countries, the doctrine has formed the basis of environmental policy legislation, allowing the private rights of action by citizens for violation by the state, directly or indirectly, of the public trust. The rule of law runs close to the rule of life, and the Indian Constitution, in its humanist vision, has made environmental ecological preservation a fundamental value. Accepting public trust doctrine as a part of common law, the Indian courts have applied this explicitly in cases, the first one in 1997 and the two cases in 1999. Article 48A and Article 51A of the Constitution of India also furnish the principles of jurisprudence, which are fundamental to our governance under the rule of law.